will be no decision before the end of this year. All right. I'm confident in saying that it's never going to happen. Do you think Judge Torres and her clerks can put together a decision of this magnitude in 6 weeks? It's just never going to happen.
In today's video, Attorney John Deaton discussed the latest news with the SEC, Ripple, XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon. Before listening to him, please ensure to smash the like button and subscribe to the channel. Let's dive into his last interview now.
Ripple filed a summary judgment motion saying that there's no reasonable jury that could ever think that they violate the law, neither should the judge, and the judge should just find that XRP is not a security as a matter of law. And they don't get into the fair notice defense. They don't get into any of that because it's just about the law, right? And the token and how it's not a security. And then the SEC and their motion for summary judgment, they're saying that they proved, and they cite evidence and stuff, that they proved that Ripple engaged in this scheme starting in 2012, and that any purchase of XRP is violating the U.S. securities laws. And so they each file their summary judgment, and now we have to wait for Ripple to give an opposition to the SEC's. That's when you'll hear about the fair notice defense. Because if you look at the two motions right now, the only one that brings up fair notice is the SEC, because they have to address Ripple's affirmative defense, saying they didn't lack notice. But it's called a fair notice defense. So it's defensive. So Ripple will bring it up when they're defending what the SEC filed. And the SEC will write an opposition to Ripple's. Those are due around the 18th of October. And then each side gets to do a reply, right? So Ripple moved for summary judgment. The SEC opposes it. Ripple gets to reply to the SEC's opposition. Same thing for the SEC. They filed their motion. Ripple opposed it. They get to reply. Those replies are due somewhere around, November 7th to the 15th, somewhere in there in November. I don't have the dates memorized. So all of the briefing will be completed by mid-November. And that's when then the clock begins to tick on how long will it take for Judge Torres to write a decision and a ruling. Okay. And so that's sort of the procedural landscape that's happening right now. Ripple's summary judgment motion, I've stated before when it first happened that it's a brilliant argument. In many ways, I hate it because, it's not like red meat. It's very much about the law and how the Securities Act of 1933, what they meant, and they incorporate all the different state laws around the different states of the country that help form that statute. So they're getting into a lot of statutory intent and things. That's why they cite things like the pre-1933 blue sky laws, right? Stuff that, normally don't hear of. Wow. And Ripple's argument for summary judgment is that in their research, that you have to have a contract before anything else. And there has to be, it's called an investment contract, that you have to have a contract. And before you even get to the Howey test, if the judge doesn't find an underlying contract, you don't even get to Howey. And then they say, well, Judge, if you disagree with us, you find that you disagree that we don't have to have an underlying contract. Well, you should find because the four factors of Howey don't apply to XRP. There's no common enterprise. XRP holders didn't rely on the efforts of Ripple. We win that way. So that's basically Ripple's argument. The SEC's argument, I got to tell you, I was proven wrong about something, Tony. I actually predicted that there would be more damaging evidence against Ripple that we didn't know about. Because we're not privy to depositions and the documentary evidence, any of that. And so I figured that there's going to be a couple of things that might be a couple bad days for Ripple publicly, right? The people would take shots at it. The haters would be able to cling on something. And I was shocked because it's really not there. There's no there, so to speak. And it basically is a marketing case against Ripple, right? Because Ripple sold XRP. They sold XRP to accredited investors, to venture capitalists, and they sold it on exchanges to the public, right? That's a fact.
Yeah.
Brad Garlinghouse, Chris Larson sold. And so the SEC is basically saying they're going with a different argument. Ripple's saying you have to have a contract, then you apply Howey. The SEC is going to argue that you don't need a contract, that the language of Howey is that a contract, transaction, or scheme equals an investment contract. And they're going to cite case law for that. And they're going to say that it's the scheme, that even though there's no contract between XRP holders and Ripple, that Ripple devised this scheme to create a secondary market and to sell XRP, give it away to some people, get selling going, establish liquidity. And they didn't have a use case, and they didn't get a use case until 2018 with ODL. And then they sold that to fund their business, their very ambitious business. And the problem with the SEC's argument, though, is that they had to concede during the litigation that Ripple owes no obligation to XRP holders. And that you owning XRP, Tony, you no claim to Ripple. And Ripple could stop using XRP and decide that Bitcoin is the coin of choice, and they're going to use Bitcoin for their ODL. And they're never using XRP again. You and me as an XRP holder, we've got no claim, right? We can complain that we want, it means. So what's missing in the SEC's case is that issue, which means where's the common enterprise? The common enterprise in the complaint was Ripple, that we are investing in XRP because of the management team of Ripple, and we're in a common enterprise with Ripple. And now that that's out, that there's no obligation, they then went with an expert witness who said that the entire XRP ecosystem was the common enterprise. That would mean you, me, Coinbase, when they listed it, Uphold that listed today, developers around the world, everybody is part of this ecosystem, and we're all in it together. And so that's the common enterprise. But I know I'm going a long time, but they didn't rely on experts. And that's something I do want to talk to you about. Sure. They didn't rely on any experts. So now what is the common enterprise? And I won't be surprised if we see in their other papers that the common enterprise, and this would come in their reply in November, is the XRP ledger, right? Because we all sort of have this interest in the XRP ledger as the native XRP being the native token. That's absurd because that's a software network. How is a software network a common enterprise? But that's basically an overview of where we stand with the summary judgments.
So to your point, there's still a lot of procedural things that have to happen. There's certain specific dates. It's October 18th, and then subsequently in November, and then this thing could potentially wrap up next year, right? Based on the updated facts, are you thinking we see some sort of conclusion sometime next year?
Yeah, unless there's a settlement, there will be no decision before the end of this year. All right. I'm confident in saying that it's never going to happen because the briefs and everything's going to be due, say, mid-November. And then the next week you got Thanksgiving, and then you got Christmas, and you got holiday season. And it's just never going to happen. And even if there weren't any holidays, do you think Judge Torres and her clerks can put together a decision of this magnitude in 6 weeks? It's just never going to happen. So people got to get that out of their mind. If there's a settlement, fine, right? That's one way that it resolves. But if it does not settle at all, if this case never settles, then the earliest, and I know it's bad news, man, but the very earliest that I would expect it would be the end of March.
Okay, of 20.
But there's a good chance, and even Brad Garlinghouse, and it's got to be based on what his lawyers are telling him. Brad Garlinghouse said, "Look, I've been told this takes between 2 and 9 months." So I won't be surprised, absent a settlement, that May 1st comes and we're still waiting.
Sure.
So people just gotta
yeah,
accept that reality. Maybe it resolves and settles, and we don't got to worry about that, but we'll see.
Yeah, it is what it is as far as the timeline. So if there is a settlement, and I know this is a bit of speculation, what do you think that looks like? Is Ripple paying a fine for 2013, 2015? XRP is free to then be relisted on exchanges, things along those lines?
Yeah, at this point, Stuart Alderati, who's the general counsel of Ripple, Brad Garlinghouse, the CEO of Ripple, they have both now publicly said on more than one occasion that they won't settle unless ongoing and future sales of XRP by Ripple or anyone else in the secondary market are not considered securities. So the problem with the settlement, Tony, is that it would require the SEC to agree to some kind of statement, right? It could be in writing, it could be publicly announced, but they would have to agree that moving forward, XRP is not going to be considered a security. And the SEC doesn't like to do that, right? Except for Bill Hinman, right? The SEC normally doesn't like to kind of give that kind of clarity to one token, allegedly. The problem that I see is more of a political one, which is you sued Ripple saying XRP is a security, including secondary market sales. And then you want to go after all these other cryptos. How do you reconcile saying XRP is not a security, but XLM is? XRP is not a security, but Algo is. XRP is not a security, but ETH today is, right? And so I'm not saying be done. I'm just saying that is a very narrow, like you got to thread the needle on that one, man. Sure. To figure out how you can publicly do this and then still be able to go after, other cryptos. And so I haven't changed my mind, Tony. Without the pressure of the Hinman emails and the documents that need to be turned over, if the SEC is not forced to do that, I don't think they settle. I know people disagree with me, and that's fine. You said it best. I'm speculating. I've always made it clear that just because I'm amicus counsel, I don't have any more insight. Your guess and speculation is just as good, just as valid as mine. My opinion is it will not unless Gary Gensler is forced, right? Because a lot of people think that, well, he won't risk a judgment because it hurts them against other crypto. And I understand that. I've said that myself at times. But we go back to, how does he say XRP is not a security, but the other ones are? It's a very delicate situation. But, I did a tweet today where a lot of people are thinking, oh, Ripple's going to win for sure because of their initial brief. They don't even get to the Howey test. That doesn't mean the judge is going to agree with that. Sure. Right? That's a very, very, very novel concept for today. And it would mean that she has to disagree with Judge Castell and Telegram and other appellate judges. And she would have to disagree with them and agree with Ripple, and she might not. And so I think that XRP holders, because we feel confident, you can't get blinded by your bias or your emotion or your passion or your conviction. And so, but if Gary Gensler's told by the judge, you've run out of appeals, can't go to the Second Circuit, your writ of mandamus has been denied, you have 10 days, and let's say it's December 1st, you have 10 days to turn over all those emails, all those comments, all those drafts. And if in those drafts and in those comments are discussions of XRP, why isn't XRP being given a pass? Hey, if you're saying it about ETH, you say it about XRP. I'm not saying that's in there, but I believe there's going to be somebody, right? Somebody's going to say, what about XRP? If that's in there, and even if it's even better, that could be a guaranteed victory for Ripple. And that's when they say to Gary Gensler, we're definitely losing. And so settle today, see if you get 50 million. And we're just going to have to say that XRP is not security. We'll figure out a political way to do it, still go after the other ones. But you'll be able to go on thinking crypto and say, I enforced the securities laws and I brought Ripple, to the table, and I forced them to acknowledge their wrongdoing between 2012 and 2017 or whenever.